I can't hear you at all. So this is Andrea Miller. I don't see anybody or hear anything. So are we ready to start? Okay, yay. All right. Well, that's good. And let me see if I can share my screen. Share, start. Okay, hopefully everybody can see this. And I can try to keep the chat open too. Sure if I should do that. Okay, well, I'm just going to go ahead and start. I know this is being recorded and I can't see anybody's faces, which is always unfortunate in these events, but I'm going to go ahead and go. I'm here today just to talk about the Violence Against Women's Act and how to maintain safe housing for survivors of domestic violence, sexual assault, dating violence, and stalking, and human trafficking actually was thrown into this as well. So we're going to talk about that just a little bit, and I'm going to share a little bit about ZeroV. We're going to go over some hypothetical scenarios just to kind of take the temperature of knowledge. If you all want to throw things in the chat and somebody can help monitor, that might be good. Um, but we kind of want to understand the new reauthorization of VAWA. Hey, hello, I see your face now.
Okay, can you hear me?
I can hear you, yes.
Okay, sorry about that, everybody. Sorry for the interruption. I had some technical difficulties, but I think we are resolved now. So I will turn it back over to Andrea.
Okay, Andrea, but okay, yes. I know it's complicated because it's not spelled the way it looks. But all right, so okay, so the objectives that I just shared again were just a little bit of an overview of Zero V, just to talk about a few scenarios. We're going to look at the 2022 authorization, most recent authorization of VAWA, and then look at some just some thoughts we have at Zero V about best practices in that. So Zero V is the statewide coalition for domestic violence and or intimate partner violence specifically under statute. We recognize that IPV is a power-based violence and it's part of a systemic pattern of oppression and violence. We have a 15 member network that are state-funded agencies that are one in every area development district in Kentucky, serving that whole area development district with a variety of services. We are in every county in Kentucky, and our shelter and outreach programs. There is one shelter, and then the outreach services are in the different counties where the shelter outside of where the shelter is. Again, they offer massive amount of services to people. As everyone who's involved in the situations with shelters knows, there's not enough space for everybody that needs it. So we really are trying to make sure that people can get access to services, even if they don't actually need a shelter, because sometimes shelter is not always necessary. Um, those are kind of our philosophies. This is just a map showing the county where the shelter is, the name of the program, and the contact number for that program, just in case anybody needs that information. Everybody here in Louisville is probably very familiar with the Center for Women and Families, which is, of course, located in Jefferson County. Um, at Zero V, we are one of the few coalitions across the country that actually operate housing directly out of the coalition. We're also one of the few coalitions that has been involved in development of housing, specifically for survivors. We have managed to have 84 developments across Kentucky. 21 units are located in Louisville, right across from the center. And then we operate those forms of housing that you see listed on the screen, which we just got reauthorization for another home TBRA allocation. It's a 2-year grant, about that's 1 year's number. And then we kind of divide it up that way for budget purposes, but basically it's a 24-month grant. We have a rapid rehousing grant in the balance of state through the Kentucky Housing Corporation, which is the collaborative applicant for the balance of state. We have DV bonus rapid rehousing grants in the balance of state, one ongoing now, one that should start in January, actually December. And then two in Louisville, one currently operating, and then two that would operate starting October 1. And then we have also an OVW transitional housing grant that will have some capacity in Louisville for 18 to 24-year-olds that are referring and working with a Spot, who is our partner on that. I think I saw Alan on the call. So, hey, Alan. Hey, Alan. And then we'll also have with LKLP, which is an agency in Eastern Kentucky. So we've got a little bit of diversity in how that grant operates. It's a 3-year grant. So we're going to talk about some scenarios now. And if you all have any questions, I'll leave room for questions at the end. If they're going to be thrown into the chat, I'll ask for help when we get to that space to be able to get to them. So the first scenario, just to kind of get us started a little bit, is about Sam. And Sam applies to live in an apartment complex. The owner declines Sam's application because she has a prior eviction and 2 arrests in the last 12 months. Upon receiving the denial, Sam calls the owner and explains that these were related to domestic violence and that she has recently left that situation. The owner tells her that he won't consider her application because he knows she's going to get back together with her ex-partner, as those in her situation typically do. So just in general, would you think that the Violence Against Women Act would apply here? And again, I'm not sure if I can see the chat and this at the same time, but I will ask someone to tell me what everybody is thinking. Do you think VAWA applies? Yes, no, what is it looking like? Any feedback would
People
be
are
great.
saying, yes, it does.
Okay, yay, all you all are right. VAWA does apply in this situation. The owner cannot deny some admission due to a private eviction if that eviction was related to domestic violence or criminal history that can be tied to domestic violence. Keep in mind that you do have to make the link in order for VAWA to apply. So sometimes that's the challenge in working with landlords, is getting something that will demonstrate domestic violence was happening here. Typically, something from a member program should work, or a VSP should work, or law enforcement should work. Some of those things should be applicable. And then scenario number 2, we've got Vicky living in an apartment with her kids. She co-parents with her on-again, off-again boyfriend. Boyfriend came to visit her, was physically abusive, punched holes in the walls. She called the police to report the abuse after the boyfriend left. This isn't the first time police have been involved in coming to her unit. However, she didn't seek a protective order against the boyfriend. She reported the incident to her landlord and requested a change of the locks. Again, do you think VAWA applies? Can the owner evict Vicky for calling the police? Can she be evicted under a local nuisance ordinance because the police have been called multiple times to her unit? Can the owner charge her for damage to the walls? And is the owner required to change any of the locks? Any thoughts?
People are answering yes. I'm assuming that's to the first question. Does
Yes. Okay,
wow.
good.
Uh,
Yes. Okay. So just to clear it up, in case we know some things, yeah, we think VAWA applies here. Can the owner evict her? No, the owner cannot evict her for calling the police. We do see sometimes leases where this phrase is in there. Sometimes those fall under those nuisance orders if law enforcement are called. If it's related to domestic violence, the person cannot be evicted. Can the owner charge Vicky for damage to the walls? Under VAWA, no. Under Kentucky's state law, if she has a DVO, the landlord can charge the perpetrator. Under VAWA, the landlord can also charge the perpetrator whether there's a protective order or not. And is the owner required to change the locks? The answer to that is they're not required. It is something that's allowable. Sometimes the resident, the victim, has to absorb that cost, which is where flexible funding from different agencies can help. It could be offered for sure, but they're not required to change those locks. Right. So I'm giving you a little bit of the law as we're going through the scenarios. So because this is a very content heavy slide presentation, which I'm happy to share out for people to have and keep as a reference for themselves. So scenario number three, we've got Tracy living in a LIHTC or low-income housing tax credit apartment. She received a termination notice from her landlord after her partner Teresa took all of her money as part of a pattern of economic abuse. Tracy submits the HUD VAWA certification to the manager and describes the abuse and her lack of income because of that. The manager demands a police report, saying she can't take Tracy's word for it. The manager also notes that the abuse has to be physical for VAWA to apply, and shared that in talking to other residents about this situation, no one saw or heard anything, so therefore it's probably not true. So can the property manager demand a police report? What do you think? Yes, no.
We're getting a lot of no's.
Okay, that is correct. They cannot demand a police report. Under VAWA, the victim chooses the method to file for their protection. Under VAWA, there's four, well, there are four different methods that can be used. A police report is one of them, but landlords cannot demand that. They can ask for it if there's conflicting information, not from other residents, but there is a little bit of conflict there. And these are situations where I would encourage bringing in legal aid or some fair housing folks to kind of help with the law side of this. But no, in general, they can't demand the police report. Does the abuse have to be physical for VAWA to apply?
The responses are no, it does not need to be physical.
That is correct under the 2022 reauthorization. Everybody is knowing everything here. This is exciting, exciting news. So yes, y'all are doing great.
Got a good
Can
educated group.
Yes, that's lovely. It's always nice. Can the property manager speak to the other residents about the victim?
Getting more no's.
Yeah, okay. VAWA has a specific provision, oh my gosh, for confidentiality, meaning that the landlord can't be running around talking to other people about the victim or investigating the victim situation by breaching confidentiality. Can't do that. Okay, number four, Luke and Laura have lived together for the past 4 years. Over the past 6 months, Laura's violence toward Luke has escalated. Luke's requested a bifurcation of the lease that is shared between them. As a result of the violence escalation, Luke's unemployed and has limited financial resources and limited support networks. What are the landlord's responsibilities to each resident or tenant, and which tenant should be required to move? Any thoughts in the chat?
We have a question. What does bifurcate mean?
It means to separate two out. That the lease then becomes one holder, one leaseholder. I'll go ahead and move forward just for the sake of time. So the landlord responsibilities to each tenant, a landlord should be providing VAWA notices to all tenants. And then in this particular scenario, which tenant should be required to move? It should be Laura. She should be removed from that lease, and she can be evicted from that unit following any laws pursuing eviction in that unit. Luke should be provided with some time to establish his eligibility for the unit still and allow time for to seek alternate housing if he's not going to be able to stay in that particular unit. Um, and we can talk in more detail about what that looks like, but these are provisions under VAWA as well. And then scenario number 5, Robin was just notified that her former partner, who was incarcerated for using violence against her, is being released from prison in the next 30 days. She immediately submits documentation to demonstrate threat of future harm if she remains in the unit and requests an emergency transfer. She'd like to move to a sister property 2 counties away to ensure her location is confidential and she is safe. There is a 2-month waiting list at the sister property. Can her request for an external transfer be honored under VAWA? Can assistance for moving costs be provided under VAWA? And can her request to be prioritized at the sister property be? Is there anything in VAWA about that, do we think?
We're getting yeses.
Okay, looking good. All right, so yes, her external transfer request can be honored. Yes, there are moving costs allowed under emergency transfer plans under VAWA. And can she be prioritized? Yes, she receives priority placement above others in her group um, in these kind of situations. So I'm going to go ahead and just start with some of the other law pieces. There's two more scenarios, and we can come back to those if there's time, but just in interest of moving forward. So as
Okay.
I had mentioned earlier, any
Sorry,
questions?
Nick had a question
Yes.
back on the previous scenario about Luke and Laura,
Okay.
asked if Laura was automatically guilty.
Yes, if there is the evidence to demonstrate that her violence is escalated, Luke has demonstrated that in whatever he submits, which he would need to submit something. Usually it's just enough in writing. And then, yes, that's enough under VAWA. So this is information from 2022 reauthorization, which is the most recent reauthorization of VAWA. It's it's an overview. This is over 200 pages of legislation. This particular presentation was developed in partnership with some of our national partners, the National Housing Law Project, the National Network to End Domestic Violence, and some other organizations. When we do this training, I've done this training for other organizations and folks, advocates, just different groups in partnership with a colleague from the National Housing Law Project who is an attorney. She usually gets most of the legal questions, and then I get the implementation questions. And so this information, again, is just compiled from that. These are the highlights of that legislation. You can certainly read all 200 and something pages if you choose. Um, but basically, VAWA is it provides housing protections for survivors of domestic violence, sexual assault, dating violence, and stalking who live in or applying for federally assisted housing. The law applies to survivors regardless of sex, gender identity, sexual orientation, disability, or age. And then these just list some of the expansions. It does not apply to market rate housing, market rental housing, and there's a little asterisk there because it will apply if you are a housing provider in terms of subsidy and you're working with a local landlord and that landlord agrees to accept that subsidy that's coming through a federal source, that unit then becomes subject to VAWA. So in some cases, it does apply to market housing if, again, that particular landlord who might not normally have to deal with that has agreed to accept that federal subsidy assistance from your program, then it applies. It also applies to all of these programs that are listed here, these HUD programs. It applies to RD programs, multifamily programs, that's the rural development group, and it applies to LIHTC, so low income housing tax credits as well. It pretty much covers any federally funded housing that's coming down through HUD. The new programs that were added under 2022 include the ones that are listed on this page. Some of the ones that we tend to see most frequently in our end is transitional housing, especially if it's for victims, dedicated for victims. So it's through OVW, the Office of Violence Against Women. We sometimes will see rural development because we serve the entire state. We don't deal specifically a lot with veterans. A lot of the victims we have, even though we track information on that, we don't tend to see a lot of victims who are also veterans. But if you are working with veterans, then this law applies. And it applies to those programs that are listed there. It has this catch-all provision that any other federal housing program that provides affordable housing to low and moderate income persons is by means of the rents or restricted rents or rental assistance or affordable housing options, then it applies. So that sometimes is where LIHTC comes in, especially. We talked a little bit in the scenarios about what survivors' rights are under VAWA. So they cannot be denied again admission. So that's the application process. Eviction, that's once you're in, or have their assistance terminated because of violence committed against them. We do see in public housing authorities across the state, which are federally funded, that victims are often evicted, even though they're a victim of domestic violence. Public housing authorities are federally funded. Still, sometimes we see that because violence that's happened in a unit, eviction
Okay, you froze up.
Okay. I somehow got cut off. I'm not sure exactly what happened. Can you hear me now?
Yes,
Okay. Do I need to share? I need to share screen again, I think.
yes.
And I don't know where it got left off. So help me with that.
Yeah, you froze up and then you went away.
Well, I'm sure the sun is shining here in Lexington, Kentucky, where I am located. But sometimes the internet just decides it's just going to stop working for no apparent reason. So I apologize. Okay. So where did we leave off? This screen, survivors'
I believe
rights.
we were at survivors' rights.
Okay. So I'm not sure where on that, but again, survivors can't be denied admission under VAWA. So that's the application process. And our scenario that talked about that was one of the first ones we did. They can't be evicted. So that's after leasing has happened or have their assistance terminated because of violence committed against them. That's where programs sometimes will want to stop assistance to a person if they're a victim, because something has happened. And then they're like, okay, well, we can't deal with this, so you're out of our program. Under VAWA, if that's a federally funded situation, you cannot do that. Under VAWA, survivors must get notice of their housing rights. This is usually done as part of the process. It's several pages in a lease agreement. Has anyone seen that? Familiar with it?
Yes.
Yes. Okay,
Yes.
good.
Yes. That,
So a lot
yeah.
of times, just like with any other leasing piece, leases can be really long, complicated documents. When I was growing up, my father especially was telling me, hey, you need to read all that stuff. Um, like the manuals that you get on how things work. But a lot of people don't read that. A lot of people don't read their leases either. And so if it's in there, they just where do I sign? Where do I initial? And then they forget about the whole thing. So this is where education, if you're working with residents, this is where education of their rights is important. If you're operating a program yourself, you have to do a VAWA lease addendum yourself if it's not part of what the landlord already includes. And so that is another way that victims can be, or potential people can be notified of what their rights might be, so that they can invoke those rights to stop eviction from happening. But I'm not sure if I got cut off before, but a lot of times what we see at the coalition and what our member programs see is we hear about it way after the fact. Um, Victims didn't know, they didn't share, they get evicted even from public housing authorities who should be aware of VAWA and are subject to VAWA. But we still see this a lot, which is why it's really important. And I'm glad that the group here at least is aware of this and can can do what we can to stop this from happening in our communities, in your community in Louisville. Also under these rights, getting back to the slide, survivors can request that the abuser be removed from the lease if they were on the lease. They can also be removed from the housing where that is applicable as well. So usually what we see is perpetrators, abusers, they were never really on the lease to begin with. That's normally what we see. But the victim invited them in. Then they want them to leave and they refuse to leave. Under VAWA, the victim can start to follow VAWA to get the person removed from the unit. But you can't do that just by calling the cops, because in a lot of places in Kentucky, if you've invited somebody in, you have to actually formally evict them, which is where you need the help of your landlord. And under VAWA, this gives you the ability to do that. If the victim was not the leaseholder, but is part of that household, or if the victim was, what's another way to say that? If they're even on the lease, but they weren't the head of household, for example. So the subsidy assistance is not coming through the victim as head, it's coming through the perpetrator as head. The victim can still, this is given time to establish their own eligibility for that assistance, whatever it looks like. And housing choice vouchers also can move, they can port under VAWA. You just have to follow the process for the housing authority in order to be able to do that. I
Andrea,
mentioned this already. Yes.
can I ask a couple of questions?
Yes, you can.
Okay, and then I'll also let you know, Lauren in the chat has asked if the abuser is on the lease, does that prevent them from received government-funded services in the future?
If the abuser is on the lease and the victim is asking for the lease to be bifurcated, the victim's going to stay in the unit and they want the abuser to be evicted. If you're asking if the abuser is banned, I don't have the answer to that information because of the violence. I don't, that's a good law question. And actually, I probably should write that down and find that out. If that was what you were asking, is that what was being asked?
That's how it appears to be in the question in the chat, yes.
Yeah, I'll make a note to try and get the answer to that, but
I
can the
think
abuser
legal
be
aid can
banned?
probably assist with that.
And they did say, yes, that is what they're asking.
Okay.
And then I didn't have the ability to type fast enough to kind of get some questions in, going back a couple of slides.
Sure.
But there was a slide where you were talking about, I think it was Luke and Laura. Luke had claimed abuse. Laura was gonna have to move. In a situation like that, what's the mandate for evidence? Like, does Luke have to
So
show
there are
up with
four
proof?
ways.
Okay.
Yeah. There's four ways for a victim to establish eligibility, and particularly focused on that. One of them is the self-certification form that the victim turns in to the property manager. Another is actually a legal documentation like a police report or a protective order or something of that sort that the victim can use to establish. The victim chooses which of the four they want to use. And then if there is, if they choose, for example, self-certification, and then it becomes a he said, she said, she said, she said, then, or he said, then you could look at, well, what other evidence do we have? Do we have someone that's working with a victim service provider that could be a third party provider that would then certify with the victim that this is what's happening? Or I think the fourth one, let's see, we've got self-certification, we've got legal documentation, we've got third party. They can use things like emails or voicemails or text messages to demonstrate threats or evidence of attempted violence or anything like that as well. Does that
Okay.
help?
Yeah, it does. I was just kind of I wondered if, just filling out that self-certification form kind of gave the prospective victim just kind of the winning hand, and if so, is that a trap that somebody could fall into? And then if there is a bifurcated lease, I know if you had to, if we had to evict somebody, that's something that can take a long time. It can take, weeks or
Yeah.
months and go through the court system. How is that managed? So if a landlord comes to Luke and Laura in that situation and says, Laura, there's, this documentation's been received. We have to bifurcate the lease. You have to move either to a different unit or to a different property. How much authority does the landlord have in that? And can they just make that happen? Or is that something that now has to go through something similar to an eviction court process?
I think it can be either way. So if Laura is agreeable to the exit and isn't going to make the landlord go through the legal channel to evict her, then that could happen. But that would be where you don't have to force something. I mean, sometimes you do have to bring the law in. And I do know, everyone knows that sometimes that takes a little bit of time. That's why VAWA emergency transfers could also make that a little bit faster. Usually the process for that is 30 days,
Okay.
pretty fast. But that could happen. It could be that the landlord is going to rent to Laura somewhere else. Landlords have the ability to do that if they choose. If they bifurcate the lease and they want to give another option to this other person, they can. That's up to the landlord. But if the person refuses to leave, like anything else, sometimes you have to go through the legal process, which I know can be time consuming.
Okay.
Hope that helps.
It
Well,
does. Thank
whatever
you.
it's worth. Welcome. Okay. Oh, okay. Evictions. So they cannot evict a tenant on the basis that they have or that they have been a victim. That seems a little bit repetitive to things that we've already shared, but we do see this happening, and this was one of the scenarios that we also talked about at the beginning. They can't be evicted or have their assistance terminated based on criminal activity that's a direct result of their status as a survivor. So sometimes what we see in terms of power and control with victims and abusers is that sometimes victims are pulled into criminal activity. They do it sometimes coercion, sometimes threats, multiple reasons. If you can tie that criminal activity directly to that relationship, then you can't use that against the person. Hope that makes sense. It also is very clear that the incident of violence isn't a serious or repeated lease violation by the victim or good cause for evicting the victims. I feel like that's repetitive. So sometimes what happens there is that sometimes violence in units aren't related to domestic violence at all, or dating violence, or stalking, or sexual assault. And if that's happened and it's not related to those things, then people can be evicted for that. So I hope that we're very clear about what is tied to DV, to the DV instances, the VAWA crimes, and what is not. And then the last part on this is just honoring court orders on property rights. So if law enforcement is involved, if the court is involved in the dissolution of a relationship, and someone has certain rights that certain pieces of property or whatever that they are entitled to, VAWA says that yes, you can still do that. And so that's another piece that's a little bit, it's protective of both parties, if you ask me, but it does require that it doesn't trump over that. Where in some instances, VAWA is asking for people to listen to victims and follow victim rights. But in this particular case, if there's court orders already in place, then those need to be followed. I hope that makes sense. People can't be evicted if an unauthorized person is the abuser. So that we talked, I don't know if I got cut off when I was sharing this before, but you can't evict someone if they invited someone in, that person turns out to be an abuser. That's where, again, they're going to invoke VAWA. You're going to try to get the unauthorized person out of the unit. There are, again, this is where that partnership with property managers and practical application of VAWA is really, really helpful. So from our perspective at the coalition, when we are seeing this, and we do, we'll talk to the landlord obviously with the victim's consent, and we'll talk to the victim. And we'll figure out what seems like the best thing to do here for everyone's overall safety. And then we're going to try, and if we have to go through the process to formally evict this unauthorized person, that we do. Sometimes the landlord just showing up and telling them, you're not allowed to be here, you're not on this lease, I expect you to be out of here. And if not, then I'm going to follow through with these things. And sometimes that's enough. It isn't always, but it sometimes is enough. So that's where, again, that education, that partnership that you have could be really, really helpful. The landlord can evict a survivor, a victim, if they can establish that there is an actual and imminent threat to other tenants or employees at the property. We've seen this. You probably have too. The threat has to consist of physical danger that is real, that would occur within an immediate time frame, and could result in death or serious bodily harm. And that actual definition of imminent threat, things that are considered is the duration of the risk, how long has this been going on, the nature and severity of what's happening, the likelihood that people believe harm could occur. So has any damage been done already to any property or to anybody's things, to a person, to any of their, like their animals or anything like that. And then any threats that are had been given by the particular abuser or perpetrator. We have seen this. We see this too. I'm sure you might have as well. And in that case, we're always looking at safety for the victim and their family, including their furry family. That's what we're going to focus on first, safety. But we have had situations where a victim has been in a unit. There is a person that's coerced or threatened their way in, or they were invited in, but then the victim doesn't want them to stay. She can't get them to leave. And then what happens is there's a lot of violence or threats of violence that escalates. Sometimes property managers are threatened, maintenance people are threatened, other residents are threatened, and law enforcement sometimes is called. That also, we have to be really careful with law enforcement from the victim side, because some victims don't have a really great history with law enforcement. So when you're involving law enforcement, you need to be aware of that, what happened there. So that's why looking at that safety piece is important. And so from our perspective, yes, we want to look at these things. And if there's a lot of threat that's happening in that community, it might be safest for the victim to leave. And then we want to expedite that as much as we can using VAWA to get them out of the lease and things like that. And then that eviction, we would not want a survivor evicted. We don't want evictions on records. We all know that there's lots of attempts right now to help some of that be eviction history to be expunged or in some way fall off in some capacity. So it's not always held against a person. But under VAWA, what we try to do is use VAWA from a practical implementation perspective, use VAWA to invoke the rights and try to avoid the eviction for the survivor. We don't really fight for the if we're trying to evict a perpetrator, we're okay with that. But on the survivor side, we're trying to avoid evictions there. And that's kind of what I was just sharing was this particular slide, is we're looking at those things. And then our recommendation is that we want to see that eviction not happening unless there's no other action that would reduce the threat. So some of those alternatives are transfer. You can bar or ban perpetrators from properties. The ability that property management has to do that varies across every community, how they do that. And that is up to the property manager. Again, they're the ones that have to do that process in their local community. And again, we've seen it across the state. It differs. Sometimes they just need to know who it is and what information about them, and then they work with law enforcement to make that happen. And I already mentioned issues with law enforcement. You can also ask law enforcement to increase presence in communities if that's helpful. Landlords can do that. Again, just keep them in mind for survivors. Sometimes law enforcement interactions with law enforcement haven't always gone well. And so that's where we want to make sure that we're doing what's best for the victim, what the victim wants. So we want to share those risks with the victim. There are other potential plans to keep the properties safe. Those are up to property management. From a victim's perspective, sometimes we do like security systems and cameras, which can be helpful. And we have funding for. And then there might be other legal remedies that would prevent a perpetrator from acting on a threat. In most instances, this is looking at like national law. So for state law, we do have protective orders. Not every victim wants to get a protective order or needs a protective order. And I don't know if anybody has any particular thoughts about that. We never ask for them to do that. We don't ever force that. We just talk about what the benefits are and what the potential issues could be. The victim knows their story and their situation better than any of us do. And so it's important that we listen to them about what they feel on that particular instance. Any comments, questions on that? Okay. This slide is going back to the admissions process. So that's applications. And so again, based on the scenario, which you already all knew the answer to, public housing authorities, landlords, and owners can't deny an applicant housing based on the applicant being a survivor. Any adverse factors resulting from that abuse, like poor credit history or poor or criminal history, if those can be linked or tied to domestic violence, they shouldn't be considered for admission. And that's kind of the summary of that admission piece. And then the next one I'm going to chat about is that confidentiality one that we also mentioned in the scenario, that information that's submitted by a survivor under VAWA has to be maintained in strict confidence, and housing providers shouldn't be allowing just anyone administering assistance or employees to have access to that information unless they need that information to do their job. It shouldn't be confidential information on victims shouldn't be entered into shared databases about their victim status, except if they give consent. And that consent needs to be in writing. It needs to be time limited. We have sample releases that the National Network to End Domestic Violence recommends. We use those with our own project. Or if it's required for use in the eviction or termination hearing, or if it's otherwise required. So VAWA has the confidentiality protections. That's the important part to know. The types of documentation you asked about earlier. And so here are the four. The VAWA self-certification form, the HUD form. It's recently been, I haven't seen the new one yet. I actually have a copy of it. But it's been revamped a little. So there's a VAWA self-certification form. We mentioned also police, court, or administrative records. It can be from any of those particular agencies under VAWA. It could be a statement from a third party. That could be a victim service provider, a medical provider, a medical professional, a mental health professional, or an attorney. And it should be signed by both of those folks. And it usually, we always recommend that it be notarized, which is kind of what the penalty of perjury suggests. And then the other statement that I mentioned that could be used at the provider's discretion. This is where just accepting threats or emails or text messages or social media posts that demonstrate that threats have been made and have been made against that person. If the landlord is willing to, the provider is willing to accept that, number 4 can be used. So comments or questions on documentation? Emergency transfers, this is just general information, and anyone who is operating funding, federal funding coming through, have to have an emergency transfer place for VAWA that allows that resident to go to another unit. It could be one of the properties units, or it could be an outside unit. That's determined by the victim and the landlord, mostly the victim. The victim's going to decide what they want to do. And there is a form for that as well, that can be used. It has the same documentation requirements. The emergency transfers, those 4 that we just talked about, are under the same documentation requirement as just invoking VAWA, not from an emergency perspective. It also can help with the moving costs. That was one of the scenarios that if they're using an emergency transfer process, there could be funding in that for moving and the preference. And this is again is where that partnership between housing, which is your housing provider, subsidy provider, the landlord who's accepting it, the victim who's living there, everybody needs to be working together to make this be a smooth process. And then Section 8 vouchers can also be transferred under emergency transfers as well. Lease bifurcations, this is where one of the scenarios we talked about being able to bifurcate a lease if both people were on the lease. And that does again mean to split the lease. And then you can evict the abuser, allow the victim to stay. You can let the abuser stay, allow the victim to leave. Either one of those is fine. We let the victim choose which one it is that they prefer. And then if the individual who was evicted or is asked to leave, and they is the sole tenant that was eligible, so they're the owner of the recipient, whatever, of the housing assistance, the provider needs to let the remaining person give them time. It's 90 days or to the lease expiration. It can be extended, and this is all under VAWA, to move or establish eligibility for another housing program. So the landlord has to follow all the rules if they're going to evict somebody. And then housing choice voucher programs, if the family breakup results is because of violence, the PHA has to ensure the victim retains the assistance in that particular case. Does all that make sense? Also in the scenarios, we reference some updates. Was somebody going to say something?
No, I
Sorry.
was just saying, yes, it does.
Okay, thanks. It's so hard when you can't see things. Okay, so the VAWA 2022 updates, some of the highlights from that, and I did share some of these already, were the updated definition of domestic violence that includes the ways that people cause harm through domestic violence, which is economic abuse. About 99% of victims experience economic abuse. It looks like things like taking someone's paychecks, controlling all the money, not allowing someone to work. Um, those are some of the ones that come to the top of my mind. I'm sure there's many others. You might have seen some of these as well. Technological abuse is also included in this as well. These were new, added in. And this is where in the scenario we talked about, does the violence have to be physical? Most of the time when people think about abuse, they think of physical violence. But often what's much more common are the other forms of violence, particularly emotional abuse and control and financial control. And physical assault and physical abuse absolutely happen. Sometimes they're another form of control. And usually when things escalate to the physical sense, the other forms of control haven't been working. And so then physical threats come into play and physical violence occurs. So that's usually what we see. But this was finally recognized at the federal level in this particular one, is that there was a lot of harm being caused by economic abuse. That also, I don't think I mentioned this, but I did earlier, the debt, credit, debt, overdraws with banking accounts and things like that. Those are all forms of economic abuse. VAWA also included protection from retaliation, intimidation, and interference, which means that people who are exercising their rights through VAWA are protected against retaliation, whoever. It could be a landlord or it could be the perpetrator, but they're protected from those things. There is a complaint process for enforcement through VAWA. You can do that through the channels where you would normally do violations that relate to housing. RD has their special portal, I think, Rural Development does. We usually tend to work with Fair Housing, the Fair Housing Council, to help us with things like this if we can't get resolution working directly with property management and with victims. They're really good partners. I don't know if anybody here is familiar with them. I think, did they present last week? Maybe? Could
Yes,
be
they
crazy.
did.
Okay, I thought so. And they might have talked about some of this in some of because sometimes they pull things in, especially when they're talking about fair housing, and those that could be more applicable to the gender-based issues. That's usually what they see. They're great partners. We love working with them and highly recommend it. If you can't get resolution or you're looking for even just advice, they are a great place to call. Other updates are the rights to report crime against the things. Some, we all know whistleblower. That's what everybody thinks of when you talk about stuff like this. It's the same here. You can seek the assistance that you need. It also prohibits the nuisance laws that I mentioned in one of the scenarios that impose penalties on people for calling the police. What that says when you put that in a lease agreement to a victim is I can't call the police if I need help, because if I call the police because I need help, I'll get evicted. That's the last message I think that anybody wants to send here. I don't think that's what's meant by those clauses and lease agreements, but that's how they're interpreted and sometimes how they're enforced. Because we have seen landlords try to evict victims, give them a notice that they're going to evict them because the police have been called too many times to their unit. The police have been called for domestic violence. And so if that's happening, then landlords shouldn't be evicting the people. Maybe the landlord doesn't know that's what's happening, and that's why that's important, that that be disclosed so that they don't do that. We've seen a lot of larger property management groups also just take that clause out of their lease. I don't know if you're seeing that in Louisville, if anybody's seeing that. We're seeing it in the balance of state a lot. Okay. It also added in entities that are receiving community development block grant funding. They have also obligations. We did not list all of those in this particular law, but under that particular section, it's the same thing. They're also prohibited from imposing those penalties. They're also responsible for reporting things, and VAWA also allows for training and technical assistance. I mean, you can get that from some of the partners that we mentioned, including ZeroV, but it also can come from places like people who have funding to be able to do the training and technical assistance. Fair housing groups are usually some of those. The legal aid societies are usually some of those. We tend to go to the National Housing Law Project. And I'm going to chat a little bit about Kentucky's law because Kentucky does have some housing protection rights in it. It was authorized in 2017 under what was House Bill 309. It was part of a larger bill. That was also the bill that ended mandatory reporting for spousal abuse, mostly because we wanted to expand protections and those laws weren't working in the way that were best for survivors. So now it's mandatory education, which is better than reporting something that the cabinet is not able to manage or handle in those particular instances. So under Kentucky law, part of the housing protections that were added were similar to what you can get with VAWA. So for example, under Kentucky law, landlords can change the locks. Under Kentucky law, still just like VAWA, the tenant might pay. Sometimes landlords will do it and they just absorb that on their own. But sometimes they'll say, hey, this is going to cost this. And from our perspective, we provide that using some other funding sources that we have, if they're folks that we're working with. There are other agencies that will do the same thing, that will help a resident who is experiencing a little bit of a cash flow problem in being able to manage that expense. Lease bifurcations under Kentucky law can happen. Early lease termination under Kentucky law can happen. Relocation can happen. The only difference or thing that Kentucky law requires, and this was something that was kind of negotiated, but still, I mean, it's not what we wanted, but it's what we were able to get in order to get these other protections passed. Kentucky law requires a permanent domestic violence order, a DVO. You have to have the protective order if you're invoking VAWA in Kentucky law. Any comments, questions about that? Has anybody ever used Kentucky law, or is anybody using VAWA? Yes.
I've never had any experience with VAWA other than, the initial like lease forms.
Okay. We're seeing it a lot, and we're tracking it in our housing grants, how often we're using VAWA. It's usually half a dozen easily. Sometimes one person multiple times for safety reasons. But yeah, so we're able to successfully make it work. If you all come across it and need some help, please feel free to reach out to us. We would be happy to walk through some of the things that we have found to be successful in actually implementing, again, this very complicated legislation. This slide is referenced under fair housing. And this is the part where we just kind of tie it in a little bit to the fair housing piece, because survivors' rights under fair housing, because of the disparate impact, because of gender-based violence, is the same thing, is that survivors' rights are to anybody's rights are to be free from discrimination when seeking housing, whether it's rental or whether it's purchase, to be protected from eviction from that. If you're a victim, to be treated the same as other residents or occupants. One of the examples that I can't remember if we had it in this particular presentation, but usually we use this, and it's where sometimes the survivor is penalized for damage done to a unit by a perpetrator. But then another person who is a victim of a different crime, not domestic violence, but a different crime where there's physical harm done to a unit, landlords don't evict that person. That's the difference. And so that's discrimination. So that kind of falls here. And then people have rights to request reasonable accommodations, and then equal access, which is still law. I know that there's a challenge to that and things going through, but right now equal access is still a law. And so this, yeah, we did put the slide in here. So a landlord evicts a rape survivor after someone assaulted her in her unit and she called the police, but doesn't evict another resident after somebody broke into their unit and they called the police. In this particular instance, the pronouns were clear between gender, it's gender violence here. The next example, a landlord's evicting a survivor because of damage, but doesn't evict a male person to damage caused by either a break-in or a guest of his. And so it's just kind of those situations. And so we're coming up on the end of the slide presentation, and I'll definitely leave time for some more questions. But some of the things that we do at ZeroV as a housing provider is absolutely recognize that it's a collaboration between us, the provider of the substances and the subsidies and supportive services, the landlord who's our partner, and the survivor who's our partner. We all want to be working together to make housing successful. So anything that we can all do together to make housing successful, we're always trying to preserve housing. Um, and if it looks like someone has done things that are like lease violations that aren't related to domestic violence, that we feel it's everybody's best interest to end that partnership with that landlord, then we want to preserve housing somewhere else for that particular person, giving people as many options as we can to stay housed. We like landlords that have low barrier tenant selection plans. We encourage that. We also will encourage landlords if they have very strict like income policies or things like that as part of their application process, would they consider working with us? And here's what we do. And sometimes we're able to get that going. The grants, housing grants, they have different uh, incentives that can be offered, things like double security deposit. Some ESG grants had other incentives built into those, but whatever housing you might be operating, there might be a way for you to incentivize landlords. We also know that with supportive services, we're trying to help landlords ensure quality. We want to make sure that, again, everyone's working to take care of the unit. Landlords do their part, residents do their part. We all know that we have a massive housing shortage, so we really want those relationships to work, and we want to help landlords keep their units filled. And if they have real high barrier units, then it makes it harder to kind of keep them filled. And so I think that that's another way that we can kind of talk to landlords about some of those things. We also look at the supportive services as trying to resolve any issues that are putting that housing at risk. It includes rental assistance from the perspective of, in our project, some residents who have income might have a rental share, and sometimes there's changes in income. If we can adjust subsidies very quickly, we do. We are much more flexible with that than some other housing providers like your classic Section 8. But the end goal for us is to get people stable for the time that we have them, move them on to permanent housing, whatever that looks like for them. And so that then prepared to deal with some of the programs that have more rules, laws involved in them that we can be more flexible with. That includes like adjustments to income and rental assistance and things like that. From the survivor's perspective, we ask them to also reach out to us if they're experiencing issues. We do landlord check-ins as well. Like we just check in the landlord. We're not asking for personal details about the survivor. And we don't share personal details. Survivor. We're just saying, hey, how's everything going? Anything we need to know. And so we ask landlords to let us know about those things so we can head problems off at the pass. That's from our perspective, what seems to be the best in helping people preserve housing. And then we also have flexible funding that we raise. Anybody who wants to donate, you can. We're always looking for donations for our unrestricted funding. It is used literally to help people get things they need to get into units. People have to leave situations sometimes with nothing but the clothes on their back. It's very expensive to replace things like dishes and bedding and things that sometimes your housing grants won't cover. So flexible funds help us do that. It also helps us to clear debt like utility debt and or other things that are keeping people from being housed. So that flexible funding piece is something that we think is key for anybody that's operating housing, and it helps with VAWA as well. It helps us implement VAWA. Even though there's funding in some of our HUD grants for VAWA specifically, we can also use our flexible funds to help. And then from our perspective, again, we mentioned making sure people have this information about VAWA. We share it with our member programs and with our program advocates so that they're aware and that we can spread that in Kentucky far and wide. We did a training yesterday for some housing advocates. We touched on VAWA a little bit. One of the advocates asked me, was there any, she wanted to know how come more people didn't know about this? And I don't have the answer to that. I think things like today and things like yesterday are ways to do that, but sharing VAWA and its protections is how people are aware. And she used a specific example of needing to know that because it could have preserved housing for someone at a pretty good rate, but because no one invoked VAWA and it she said it was a public housing authority, so I'm assuming they should have known about VAWA, but maybe they weren't aware that that was happening in this case, or maybe they were and they didn't care. That's the worst problem. Either way, we want to make sure that this information gets out. Our goal is always to connect survivor households to permanent housing and restore senses of community. Sometimes we do that with these interim grants. Landlord engagement is really important to help landlords know. I had a property manager tell me one time that the survivor didn't get to choose which form of documentation they could use to invoke their VAWA rights. She did not believe the survivor when the survivor was sharing with her what was happening. And she told me that her husband was a police officer, so she knew all about this. I sent her the snapshot from the legislation and I said, I think you need to relook at this. Um, Something that happened later was that person was no longer working there. I have no idea what happened, but what I know is they weren't listening and looking at even their own documentation of what their own VAWA lease information says. So I do think that's important to help landlords better understand what their responsibilities are if they're accepting this federally funded housing subsidies. And I think that once we know, we can all be in a better position to help provide the information and call attention to it to avert, especially evictions. It's really all about preserving housing. We always try to discuss the VAWA protections and the application of it with our persons. Again, remembering that when people are moving in, especially people who've experienced trauma, and there's a lot of damage done to the brain sometimes, people who've been under long-term trauma, and you're trying to help people encourage their brain to engage its plasticity and kind of fix itself. And one of the ways to do that is giving people information, helping them understand the information, helping them to be able to invoke the information and not be afraid to share that. And so that's one of the things we want to remind people of. Sometimes they're afraid to tell us because of previous experiences that something might be happening. So that's why if we can get the information earlier, we can kind of stop an eviction from happening if possible, if that's what's safe and if that works best. I mentioned most of these other things that the one thing that we really can't do a whole lot about is lease violations that aren't related to domestic violence. Those do happen. And usually we might still try to preserve housing if we can. If not, we're probably going to relocate the person. And if we do invoke VAWA, what we also recognize is that a VAWA doesn't guarantee that someone's security deposit can be returned or will be returned. It just doesn't. Landlords in our relationships have sometimes returned it to us anyway, especially if they were in the unit for just a brief window of time. Sometimes the landlords, we just tell the landlord, hey, you can keep the security deposit. We just need you to help work us get help us invoke VAWA, get this person out of this lease agreement. You under VAWA have the right to keep that. And sometimes that's enough as well. We always are listening to the survivors and invoking law enforcement or involving law enforcement folks when safety really requires that, especially if we're having to go through courts for protective orders and things like that. If people need to go back and obtain belongings, sometimes from a unit where they might have been sharing it with an abuser, sometimes encourage law enforcement being involved in for safety purposes. Sometimes victims, we want to remind them that sometimes it really isn't safe to go back and get those things, and you might need some help with that. And how can we help you? We've seen people lose their lives over going back to get something from their house. It's really tragic. Um, the last thing here are just contact numbers. Fair Housing, if you don't have their number, here's their number. Our number, if you don't have our number, is here. We do have an answering service. And we have an office manager as well who will answer the phone. Most of our staff, particularly our housing staff, is working regionally and remotely across the state. If you're trying to reach a particular area, you can get that information from calling the 502 number. If you all are interested in sending me any information, I can share, can stop the share here and enter. I can just put my email in the chat. And so you can reach out to me with any comments or questions that you might have. And so I'm looking through the chat questions. What have we not answered? Well, whoever had the fire alarm, I sure hope that got resolved and it wasn't a real fire. And then technology abuse. This is where people are using technology in order to track somebody, or in order to abuse them through technology systems. That's what that refers to. Does that help? And then, yay, Alan, get the form, talk to property management. So what other questions do you all have?
Andrea, I have a question. I had to step away for a minute when you were talking about documentation, so you may have addressed this, but did you talk about making sure that VAWA documents are kept separately in the office from regular housing or case management files?
Yeah, I did not mention that specifically. It falls under confidentiality. So if you've got a situation with the person that you're working with, and now you've discovered that they're a victim, you're going to want to protect their information in that way. You'll want to talk with them about that first, because at this point, most everybody else here is probably using like shared data systems. Is that right? Like HMIS? Yes, maybe.
Yeah, most people on here are using
Yeah.
HMIS, but I mean, like, if
Yeah.
somebody wants to move, relocate, and so you have them document on the HUD forms that they're
Right.
experiencing domestic violence, and they have to describe it and all of those kinds of things, that paperwork should be kept separately from just the regular case management or housing
I would
file.
recommend that you keep it separate because, yes, I would recommend that you keep it separate because of a confidentiality issue. You can also get an authorization from your victim if from the victim. Some of the things about confidentiality as agencies, we do need to remember there's the difference between privacy, privilege, and confidentiality. And sometimes with confidentiality, like that's where we as the providers have agreed to and share with that person, here's how we're going to protect your information. And we're not going to share it unless, and then you list the reasons that you might do that. Sometimes from the victim perspective, they might want you to share information. And so that's where you want that special release that says, hey, and you can share this about whoever you can share this. I give you permission to share this information specifically with this purpose for this with this person. And in that instance, you have a release that says you can do that. But otherwise, I would keep it as I would follow your confidentiality policy and I would keep it separate from. And I would not enter anything into a shared database that's going to disclose victim status without the victim's express permission to do that. Does that help answer your question?
Yes. And then there's a question about, what about clients that are undocumented themselves? So if you've
Yeah.
got immigration questions or issues.
Okay, so there is currently under law, which still applies, that housing under certain circumstances falls under the law that allows those things to be provided to people who are undocumented. Um, under it's a threat to life or health or things like that. We know that there are challenges that are coming to that particular population. And so from our perspective, if we have a client who is in a housing program, that we can serve them under that law with that housing program. We treat them the same way that we do everyone else. And they follow the same VAWA issues as anyone else under that particular housing program. And until someone changes that law, that's what we're going to continue to do, is treat folks who are victims of those crimes. They can still receive assistance under those laws. It applies. I don't know if you all are experiencing a lot of conflict with that. Trust me, everybody is. And I see that was Lauren. Did you have a particular question about what to do with folks who are undocumented? Is that the question? Sure.
Well,
Hey,
just
can you hear
unmute.
me now? Okay, I couldn't unmute myself, sorry. Yes, I do have a client who is still currently undocumented. She's working on getting her
Mhm.
visa. But there is some domestic violence that has occurred there, and her partner does have documentation, so that has added like another power dynamic in there as well. Um, like threatening. But they're
Mhm.
both housed within our program. But
Uh-huh.
I wasn't sure if she was eligible for all of the same rights as documented individuals as well under VAWA.
She is under VAWA. She definitely is under any of ZeroV's member programs. And in terms of rapid rehousing, undocumented folks are eligible under COC. They're eligible under some other housing programs as well. There are other rules if you're like a Section 8 provider or something along those lines. Sometimes there's prorates that happen with that's referred to as a mixed household, where one person might be documented and other people in that household might have documentation. So for example, if you were talking about um, a partner relationship and children, and the partner relationship, there's IPV happening, and one of the partners is documented, one of them is not. In that particular instance, whatever housing is being used, if that victim is still eligible under VAWA, you want to allow them time to get their own eligibility. Whether you choose to keep the other person is up to you or not. VAWA, you're allowed to work with the other person. Hope that helps answer that question. And depending
Yes.
on what your housing subsidy source is, if you're the housing subsidy source provider, if serving someone who's undocumented is allowed under that particular program, you could use that program to serve that survivor. You just have to give them time to get you some eligibility information, whatever that looks like.
Yes, she is eligible under our funding. It's like Homes with Heart. So thank you
Yeah,
so much. That was very helpful.
yeah. There are other things, she has a path. It's a long path, but if she is a victim of domestic violence, dating violence, sexual assault, stalking, those are crimes, and she has a visa path under a U visa, if she chooses to cooperate with law enforcement on that, she can do U visa. If the person that she's with um, is a U.S. citizen and she's married to that U.S. citizen, she's eligible for VAWA self-petition as a voucher opportunity. And that's usually it used to be the Cadillac of immigration vouchers. Right now, human trafficking vouchers are moving faster than anything else, followed by VAWA self-petition, then probably youth, U visas, T visas. Well, I already talked about T visas. U visas would be next probably. They can take some time, but it does give a person a path to citizenship. And if they're holding all her documentation, that's another reason to get some immigration folks involved. If she had any documentation, if they're holding that, the perpetrator is holding it. Sometimes they do that. They'll hold the person's documentation. Any documentation they have, even if it's from their home country, they'll hold all of that, or they'll destroy it. And I don't know if that's happening here or not, but we see that a lot. All of that you just mentioned. Any other questions? I can drop this presentation in the chat if anybody wants a copy. Actually, I'll just do that right now. Okay, I dropped it in there as a PDF. Hopefully, if you want to pull it down, it's available.
If for some reason people can't access it, they can email you.
Yes,
You
I'm,
gave
I'm
your
happy to
stuff.
email it out.
Yeah. Or they can email me and I can put them in touch with you.
Looks like it's dropped in there.
Oh, people are saying they're not seeing it.
Well, it says a little green check box. It says click to open. Oh, because it's host a panelist. Never mind. I have to change the little thing. Sorry, everyone. Sorry, everyone. Here we go. Okay. It's spinning around. Looks like it's loading.
There we go, everyone.
All right. Sorry.
All right, they got it now.
Yay. Okay. Well, we go over? I talked too long. I'm sorry.
No, you're fine. We've got till 1:30. So actually,
Oh,
if anybody else had any questions or comments, we've got a couple more minutes.
yay. Sorry for my internet.
That's all right.
Yeah.
I apologize to everybody for just not being able to get it up and running at the beginning, and then you got kicked off. So I feel
You
fortunate
know,
we got as
you're
much as
bound.
we
Yeah,
did.
you're bound to get it. Yeah, and I put my email in the chat. That's so funny. I only sent that to the host and panel. I guess I sent it to me and you, Laura, so that's really
Oh,
good.
okay. You want to put it in again?
I just okay. I'm so sorry. I'm not normally such a scatterbrain. Or maybe I am, I don't know. I don't think so, but there it is to everyone. That's my email. Feel free to use that to get a hold of me. But yes, if you're going to have a technology problem, it's going to be probably if I'm involved in some way. I'm telling you, there's no reason for the internet issues. Sometimes I ended up putting it on a hotspot on my phone just in case it decided to be kind of sketchy today. I will say that my neighbor is cutting down their tree, so I don't even know if that has any impact on stuff like that. But there's no. And then Laura, I want you to know I came on early just to make sure I was here and everything was
Uh-huh.
working. And then I wondered, am I in the right place? Because nobody's here.
Oh, no.
So between all of it, I think we've all survived. So
Okay,
for,
and got
for
good
another
information
time.
from us. All right. Just a reminder to everybody, you will get an invitation to complete a survey for the coalition. I ask that you please fill that out. We do take your comments and your rankings seriously as we plan for the future. Uh, Thank you, Andrea, for sharing your wealth of knowledge with us today. This has been really helpful. I think we've had some good discussion here, good questions and good points brought out.
Well, you're very welcome. And I'll just end with thank you for giving me the time. I'm always willing to work through the problem solving process with this because, like any other legislation, the practical implementation of it is sometimes complicated. And so that's why I think it helps to kind of work together and create like a community where we can definitely bring these things out, up, in the open and start to make sure that there's more awareness. So again, it can be very complicated to implement. And in the end, from my perspective, it's all about trying to preserve housing and safety for people. That's the two things. And so whatever we can do and however we can use this law to make that happen, that's where I'm coming from.
All right, thanks so much. Does anybody else have anything you want to ask while we've got Andrea here? All right, if not, then you've got her email address now. You can reach out to her or you can reach out to me and I can put you in touch with her. So I'll leave the screen up for a couple of minutes, make sure everybody gets the presentation and your email address. And so thank you, everybody. And next week we will have JCPS representatives here to talk to us about the rights of students who are unhoused. Thanks.